It seems around Valentine's Day each year, we receive more and more calls about marital rights, marital obligations, and specifically, what are parties' rights if they were to get married or if they were to remain living with someone without getting married. And what we're talking about here is financial obligations. It's very interesting that many individuals have some preconceived notions about what those rights are, or some old common law theories that they may attain rights or rights accrue simply by living together. But that's not the case. So maybe Valentine's Day is an appropriate time to talk about what the differences are. First major difference, maintenance. In New York, married couples are obligated to provide maintenance. That is, the moneyed spouse is to provide maintenance for the non-moneyed spouse. The duration and the amount vary from case to case and are subject to statute and case law. That is a requirement for married couples.
Now, I just want to reinforce what Joe said, because unmarried couples are not entitled to any type of maintenance whatsoever, as he indicated. But I often run across clients who come to me and say, wait a minute, I have a domestic partnership. I've been with my partner for the last 22 years. We're domestic partners. We registered even as domestic partners, and I am entitled to rights as a result. And I unfortunately have to tell them, no, you're not entitled to any of those rights. A domestic partnership really only signifies that you are a couple living together, for the most part, for health insurance rights and things along those lines.
Second big inquiry is retirement accounts. And what we're talking about here is 401, IRA, pension accounts. If you're married under the state of New York, in the state of New York, you're entitled to a marital portion of the retirement account. And specifically what we're talking about is from the date of marriage until the date someone commences a matrimonial action, that appreciation, that rise in those accounts is subject to distribution. And typically a spouse will get 50% of the appreciation for that period of time if they're married in the state of New York.
However, if you're not married, despite the fact that you might be living together, you are not entitled to any portion of your partner's pension or retirement account as a result of being his or her partner. It just doesn't work that way. So it's always voluntary. One person can always leave a beneficiary designation as a partner or child, anybody they so choose. But the tax implications of that will change dramatically from a married couple as well.
The third big area is property, and we're talking about separate property. And although property can be titled in one spouse's name, there are still marital rights that may accrue because of the domestic relations law. And even without the domestic relations law, there are other issues concerning commingling, so that a property in one individual's name, if they're married, may still be considered marital. And even if it's not considered marital, the non-title spouse may still be entitled to appreciation, interest, income that separate property throws off. Again, solely if they're married in the state of New York.
And interestingly enough, on a very similar note, if you're not married, but you create a joint account, each of the joint owners of that account are entitled to 50% of the balance at any one point in time. So even though you might contribute 80% of the funds to that joint account and your partner might contribute 20%, he or she can walk into that lending institution or bank tomorrow and say, I want my 50% and be entitled to it, as a matter of fact. There are ways that one can go about setting up accounts so that doesn't happen. And that would really be something like an account for convenience purposes only, where the co-signer is not entitled to the balance. They're only obligated to provide for the initial depositor.
I often get questions about Social Security and Social Security benefits that accrue during the marriage. And so if the parties are married for 10 years or more before the action for divorce commences, yes, there are certain Social Security benefits that a spouse after divorce would be able to obtain from the title spouse's Social Security account. But there are also other Social Security issues that are at play here for married couples and for partners living together.
Yeah, now if you're not married, you are not entitled to any part of your partner's Social Security benefits, unlike a married couple who would be entitled to share in Social Security benefits, or who would be entitled to Social Security benefits for his or her spouse. Partners are not entitled to that. Also, if you are raising children together and you're not married, you cannot receive any kind of survivor benefits as a result of surviving your partner or having a minor child who survives your partner as well. There is one very, very interesting update, though, that we do have to present to you. Just last week, a case came down with respect to Social Security. That case provided that the surviving partner of a decedent is in fact entitled to share the decedent's Social Security benefits as if the partner was a surviving spouse. And why? The reason for that being that individual couple lived together for many years as if they were married, but they couldn't get married because there were no marital laws for same-sex couples. So they had no opportunity, they could not get married, they lived together essentially as a married couple, and Social Security just said, okay, we are going to award benefits to the surviving partner because there was no opportunity for them to get married at the death of the first partner. Now that wouldn't necessarily carry forward to partners if one partner dies today, because you do have the opportunity to get married. Therefore, there is a distinction.
And possibly that leads to the last topic, and that's children. Whenever couples have children in New York, whether they're married or whether they're living together, there are obligations. There are custody rights that you would have. There are child support obligations, college, child support, extracurriculars. These all apply whether you're married or not once you have children in the state of New York.
And also, interestingly enough, if you are a parent with a partner, or you intend to be a parent with your partner, and you want to avoid any chance that someone might question your parentage, New York just allowed, or just enforced last year, they put into play a new law which provides that you can seek a pre-birth parental order, which basically indicates that you are the parent of the child to be born. It's a boon for people who seek IVF, fertility, things along those lines.
So we hope some of this information has been helpful, especially as they are, relative to new laws, children, and families. And we wish everyone a happy Valentine's Day.
Enjoy.